Labor law in India is highly fact-specific and varies across states and sectors. What works for one business may not work for another. India's labor laws have been debated for decades, both at home and internationally. The present government has tried to fix this. It had attempted to consolidate over 40 central statutes into 4 comprehensive labor codes, covering wages, industrial relations, social security, and occupational safety, health, and working conditions. Looking at the substance of the labor codes, it is largely a repackaging exercise. The direction of reform is right. But for now, the challenges that have always characterized India's labor environment remain largely in place. Investors should continue to approach India's labor environment carefully. Hello and welcome back to the Veyrah Law series. As we near the end of our introductory series on doing business in India, we wanted to touch on a few topics that are outside our core domain of expertise. But as deal lawyers, these are areas we encounter regularly with clients. And they're important enough to cover at a high level for the sake of thoroughness of the introductory series. Today's topic is human resources, or more specifically, how to manage your HR requirements if you own Indian operations. This is most relevant for strategic investors running a wholly owned subsidiary or actively managing a joint venture company in India. My name is Ajay Joseph. I'm a partner at Veyrah Law. We are a law firm based in Mumbai, India. You can find more information about me and Veyrah Law on our website. The link is in the description below. Before we get started, a quick reminder. These videos are not advertisements or solicitations. They are only for sharing information. Nothing shared here should be treated as legal advice. Please consult specialist subject matter advisors before making any decisions. Lastly, please read the disclaimers carefully. With that done, let us get into today's topic. Let us start with why labor management in India has been such a persistent concern for foreign investors. India's labor laws have been debated for decades, both at home and internationally. The main criticism has always been the same. Once you hire workers in India, letting them go is very difficult. In a factory setting, terminating workers above a certain headcount requires prior approval from the state government. That is not a commercial decision. It is a bureaucratic one. And beyond that, the sheer number of laws involved made compliance feel like a maze of state rules, forms, and filings. To its credit, the present government has tried to fix this. It had attempted to consolidate over 40 central statutes into 4 comprehensive labor codes, covering wages, industrial relations, social security, and occupational safety, health, and working conditions. The aim was to simplify compliance and reduce the burden on businesses. However, as of date, only 29 statutes have been consolidated into the 4 labor codes. Further, the labor codes have been enacted, but the rules have not yet been fully notified across all states. So the transition is still underway and uncertainty remains. So does this consolidation represent genuine reform, or is it largely old wine in new bottles? Honestly, looking at the substance of the labor codes, it is largely a repackaging exercise. The structure has changed. Many of the underlying obligations have not. Take retrenchment in factories as an example. Under the new Industrial Relations Code, you still need prior state government approval before retrenching workers above a threshold. The threshold has been raised from 100 workers to 300. States can raise it further, but the fundamental requirement for government approval remains. Similarly, requirements under the Contract Labor Regulation continue much as before. The old Contract Labor Act has been absorbed into the new Occupational Safety, Health, and Working Conditions Code, but the core obligations on principal employers have largely been preserved. There are some genuine improvements. Fixed-term employment contracts are now permitted. This allows businesses to hire for specific durations without the obligations that attach to permanent employment. That is a useful change, but it is an incremental improvement, not a structural overhaul. The honest conclusion is this: the direction of reform is right, but for now, the challenges that have always characterized India's labor environment remain largely in place. Given that backdrop, what should investors actually do? The following is not an exhaustive guide. We strongly recommend engaging a specialist labor law advisor for your specific situation. But here are the broad principles we share consistently with clients operating in India. First, keep your core headcount lean. In a services business, only engage core essential staff directly as employees of the company. For support functions, facilities, security, housekeeping, administration, use contract labor supplied through registered contractors. This reduces your direct employer liability and gives you much greater flexibility. The same principle applies in manufacturing or asset-heavy businesses. Outsource non-essential work to third-party service providers wherever feasible. Second, never supervise contract workers directly. This is one of the most important points in this entire episode. Indian courts have consistently held that if a principal employer directly supervises and controls contract workers, those workers can be treated as deemed employees of the principal employer. That means full employer obligations could apply: provident fund, employee insurance, gratuity, and more for workers you intended to engage only as contract labor. Always ensure that day-to-day supervision is handled by a representative of the contractor, not by your own management team. Third, understand the thresholds for social welfare compliance. India's social welfare laws, including the ones for provident fund and insurance, kick in once you cross certain headcount thresholds. The provident fund regime generally applies from 20 employees, and the insurance regime generally applies from 10 employees, though this can vary by state. The new code on Social Security will eventually consolidate these under broadly similar thresholds. Know these thresholds before you start hiring. Once they are crossed, compliance is mandatory. Non-compliance carries financial penalties and potential personal liability for management. Fourth, use consultancy arrangements for senior and specialist roles where you can. For roles that are project-based, advisory, or deliverable-driven, consider engaging people as consultants or retainers rather than employees. When structured correctly, this significantly reduces employer obligations. Remote and hybrid working arrangements have made these structures easier to defend, since flexible working hours and no fixed place of work are consistent with a consultancy relationship. But balance this against confidentiality and data protection concerns. If a consultant has access to sensitive business information, proprietary technology, or client data, ensure there are robust confidentiality and IP assignment clauses in the agreement. Fifth, invest in proper employment agreements for senior management. For C-suite and key management hires, put proper employment agreements in place. These should clearly set out terms of engagement, performance expectations, compensation, and termination provisions. A few important points specific to India to be noted here. Non-compete clauses are generally not enforceable in India after the employment ends. Garden leave arrangements where an employee is paid their full salary through a notice period during their employment but kept away from active work are more defensible and can serve a similar commercial purpose. Nonetheless, keep non-competes in your agreements for deterrent value, but your real protection comes from strong confidentiality clauses, IP assignment provisions, and paid garden leave. With those principles in mind, let us bring this together. To summarize, India's labor reforms are moving in the right direction, but on paper at least, the new labor codes do not fundamentally change the nature of the obligation that have always applied. The structural challenges remain largely intact for now. Investors should continue to approach India's labor environment carefully. Keep direct headcount minimal in the early stages. Use contract labor for non-core functions. Build the right safeguards into employment and consultancy arrangements from the outset. And please, engage a specialist labor law advisor. Labor law in India is highly fact-specific and varies across states and sectors. What works for one business may not work for another. Do not simply copy what someone else has put in place. One would do well to recall the famous saying, "Give me 6 hours to chop down a tree, and I will spend the first 4 sharpening the axe." In an Indian HR context, getting your structure right before you start hiring is always time better spent than fixing problems after the fact. We hope this episode has given you a useful overview of the human resources landscape in India. In our next episode, we will be looking at the Indian tax regime, another area that demands careful attention from any foreign investor. If you found this video useful, please do share it with others who may benefit. Thank you for watching and see you in the next episode.